In the case of Lambino versus Commissions on Elections, on February 15, 2006, the Lambino Group, namely Attorney Raul L. Lambino and Erico B. Almontado, with other groups and individuals, commenced gathering signatures for an initiative petition to change the 1987 Constitution. On August 15, 2006, the Lambino Group filed a petition with the Commission on Elections to hold a plebiscite that will ratify their initiative petition under Section 5B and C and Section 7 of Republic Act No. 6735, or the Initiative and Referendum Act. The Lambino Group alleged that their petition had the support of 6,327,952 individuals, constituting at least 12% of all registered voters, with each legislative district represented by at least 3% of its registered voters. The Lambino Group also claimed that the Commission on Elections election registrars had verified the signatures of the 6.3 million individuals. The Lambino Group's initiative petition changes the 1987 Constitution by modifying Sections 1 to 7 of Article 6 and Sections 1 to 4 of Article 7, and by adding Article 18 entitled Transitory Provisions. These proposed changes will shift the present bicameral-presidential system to a unicameral-parliamentary form of government. The Lambino Group prayed that after due publication of their petition, the Commission on Elections should submit the following proposition in a plebiscite for the voters' ratification. Do you approve the amendment of Articles 6 and 7 of the 1987 Constitution, changing the form of government from the present bicameral-presidential to a unicameral-parliamentary system, and providing Article 18 as transitory provisions for the orderly shift from one system to the other? On August 31, 2006, the Commission on Elections denied due course the Lambino Group's petition for lack of an enabling law governing initiative petitions to amend the Constitution. The Commission on Elections invoked the Supreme Court's ruling in Santiago v. Commission on Elections, declaring Republic Act No. 6735 inadequate to implement the initiative clause on proposals to amend the Constitution. Hence, the Lambino Group filed a petition for certiorari against the Commission on Elections before the Supreme Court. The Lambino Group contends that the Santiago case is not a binding precedent. Alternatively, the Lambino Group claims that the Santiago case binds only the parties to that case, and their petition deserves cognizance as an expression of the will of the sovereign people. In his comment to the Lambino Group's petition, the Solicitor General joined causes with the Lambino Group, urging the Supreme Court to grant the petition despite the Santiago ruling. The Solicitor General proposed that the Supreme Court treat Republic Act No. 6735 and its implementing rules as temporary devices to implement the system of initiative. Various groups and individuals sought intervention, filing pleadings supporting or opposing the Lambino Group's petition. The opposing interveners, among others, challenged first, the validity of the signature gathering and verification process. Second, the Lambino Group's compliance with the minimum requirement for the percentage of voters supporting an initiative petition under Section 2, Article 17 of the 1987 Constitution. And lastly, the nature of the proposed changes as revisions and not mere amendments as provided under Section 2, Article 17 of the 1987 Constitution. Thus, the Supreme Court was tasked to resolve the following issues. First, does the Lambino Group's initiative petition comply with Section 2, Article 17 of the Constitution, on amendments to the Constitution through a people's initiative? Second, are the Lambino Group's proposed amendments to the Constitution, changing the present bicameral-presidential system to a unicameral-parliamentary form of government, allowed under Section 2, Article 17 of the Constitution? And, lastly, should the Supreme Court revisit its ruling in the Santiago case, declaring Republic Act No. 6735 incomplete, inadequate, or wanting in essential terms and conditions to implement the initiative clause on proposals to amend the Constitution? In resolving the foregoing issues, the Supreme Court held that the Lambino Group miserably failed to comply with the basic requirements of the Constitution for conducting a people's initiative. Thus, there is even no need to revisit the Santiago case, as the Lambino Group's petition warrants dismissal based alone on their glaring failure to comply with the basic requirements of the Constitution. As to the first issue, the Supreme Court resolved that, no, the Lambino Group's initiative petition does not comply with Section 2, Article 17 of the Constitution, on amendments to the Constitution through a people's initiative. Section 2, Article 17 of the Constitution is the governing constitutional provision that allows a people's initiative to propose amendments to the Constitution. This section states that amendments to the Constitution may likewise be directly proposed by the people, through initiative, upon a petition of at least 12% of the total number of registered voters, of which every legislative district must be represented by at least 3% of the registered voters therein. The deliberations of the Constitutional Commission vividly explain the meaning of an amendment directly proposed by the people, through initiative. Upon a petition, the framers of the Constitution intended that the draft of the proposed constitutional amendment should be ready and shown to the people before they signed such proposal. The framers plainly stated that before they sign, there is already a draft shown to them. The framers also envisioned that the people should sign on the proposal itself, because the proponents must prepare that proposal and pass it around for signature. The essence of amendments directly proposed by the people, through initiative, upon a petition, is that the entire proposal, on its face, is a petition by the people. This means, two essential elements must be present. First, the people must author and, thus, sign the entire proposal. No agent or representative can sign on their behalf. And, lastly, as an initiative upon a petition, the proposal must be embodied in a petition. These essential elements are present only if the full text of the proposed amendments is first shown to the people, who express their assent by signing such complete proposal in a petition. Thus, an amendment is directly proposed by the people, through initiative, upon a petition, only if the people sign on a petition that contains the full text of the proposed amendments. The full text of the proposed amendments may be either written on the face of the petition, or attached to it. If so attached, the petition must state the fact of such attachment. This is an assurance that every one of the several millions of signatories to the petition had seen the full text of the proposed amendments before signing. Otherwise, it is physically impossible, given the time constraint, to prove that every one of the millions of signatories had seen the full text of the proposed amendments before signing. The framers of the Constitution directly borrowed the concept of people's initiative from the United States, where various state constitutions incorporate an initiative clause. In almost all states which allow initiative petitions, the unbending requirement is that the people must first see the full text of the proposed amendments before they sign to signify their assent, and that the people must sign on an initiative petition that contains the full text of the proposed amendments. The rationale for this requirement has been repeatedly explained in several decisions of various courts. Thus, in Capizzuto v. State Ballot Commission, the Supreme Court of Massachusetts, affirmed by the First Circuit Court of Appeals, declared that a signature requirement would be meaningless if the person supplying the signature has not first seen what it is that he or she is signing. Further, and more importantly, loose interpretation of the subscription requirement can pose a significant potential for fraud. A person permitted to describe, orally, the contents of an initiative petition to a potential signer, without the signer having actually examined the petition, could easily mislead the signer by, for example, omitting, downplaying, or even flatly misrepresenting portions of the petition that might not be to the signer's liking. This danger seems particularly acute when the person giving the description is the drafter of the petition, who obviously has a vested interest in seeing that it gets the requisite signatures to qualify for the ballot. Likewise, in Kerr v. Bradbury, the Court of Appeals of Oregon explained that the purpose of the full text requirement is to provide sufficient information so that registered voters can intelligently evaluate whether to sign the initiative petition. Publication of full text of amended constitutional provision is required because it is essential for the elector to have the section, which is proposed to be added to, or subtracted from. If he is to vote intelligently, he must have this knowledge. Otherwise, in many instances, he would be required to vote in the dark. Indeed, it is basic in American jurisprudence that the proposed amendment must be incorporated with, or attached to, the initiative petition signed by the people. Moreover, an initiative signer must be informed, at the time of signing, of the nature and effect of that which is proposed, and failure to do so is deceptive and misleading, which renders the initiative void. Section 2, Article 17 of the Constitution does not expressly state that the petition must set forth the full text of the proposed amendments. However, the deliberations of the framers of our Constitution clearly show that the framers intended to adopt the relevant American jurisprudence on people's initiative. In particular, the deliberations of the Constitutional Commission explicitly reveal that the framers intended that the people must first see the full text of the proposed amendments before they sign, and that the people must sign on a petition containing such full text. The proponents of the initiative secure the signatures from the people. The proponents secure the signatures in their private capacity and not as public officials. The proponents are not disinterested parties who can impartially explain the advantages and disadvantages of the proposed amendments to the people. The proponents present favorably their proposal to the people, and do not present the arguments against their proposal. The proponents, or their supporters, often pay those who gather the signatures. Thus, there is no presumption that the proponents observe the constitutional requirements in gathering the signatures. The proponents bear the burden of proving that they complied with the constitutional requirements in gathering the signatures, that the petition contained, or incorporated by attachment, the full text of the proposed amendments. Here, the Lambino Group miserably failed to discharge that burden. The Lambino Group's proposed changes were not incorporated with, or attached to, the signature sheets. There was not a single word, phrase, or sentence of text of the Lambino Group's proposed changes in the signature sheet. Neither does the signature sheet state that the text of the proposed changes is attached to it. Attorney Raul L. Lambino admitted this during the oral arguments before the Supreme Court. The signature sheet merely asks a question whether the people approve a shift from the Bicameral-Presidential to the Unicameral-Parliamentary system of government. The signature sheet does not show to the people the draft of the proposed changes before they were asked to sign the signature sheet. Clearly, the signature sheet is not the petition that the framers of the Constitution envisioned when they formulated the initiative clause in Section 2, Article 17 of the Constitution. Attorney Lambino, however, explained that during the signature gathering from February to August 2006, the Lambino Group circulated, together with the signature sheets, printed copies of the Lambino Group's draft petition. But the Supreme Court was not convinced that the Lambino Group prepared, printed, circulated, from February to August 2006, during the signature gathering period, the draft of the petition they filed later with the Commission on Elections. The Lambino Group are less than candid with the Supreme Court in their belated claim that they printed and circulated, together with the signature sheets, the petition or amended petition. Nevertheless, even assuming the Lambino Group circulated the amended petition during the signature gathering period, the Lambino Group admitted circulating only very limited copies of the petition. During the oral arguments, Attorney Lambino expressly admitted that they printed only 100,000 copies of the draft petition they filed more than 6 months later with the Commission on Elections. Attorney Lambino added that he also asked other supporters to print additional copies of the draft petition, but he could not state with certainty how many additional copies the other supporters printed. Attorney Lambino could only assure the Supreme Court of the printing of 100,000 copies, because he himself caused the printing of these 100,000 copies. This admission binds the Lambino Group and establishes beyond any doubt that the Lambino Group failed to show the full text of the proposed changes to the great majority of the people who signed the signature sheets. Thus, of the 6.3 million signatories, only 100,000 signatories could have received with certainty one copy each of the petition, assuming a 100% distribution with no wastage. If Attorney Lambino and company attached one copy of the petition to each signature sheet, only 100,000 signature sheets could have circulated with the petition. Each signature sheet contains space for 10 signatures. Assuming 10 people signed each of these 100,000 signature sheets with the attached petition, the maximum number of people who saw the petition before they signed the signature sheets would not exceed 1 million. With only 100,000 printed copies of the petition, it would be physically impossible for all, or a great majority, of the 6.3 million signatories to have seen the petition before they signed the signature sheets. The inescapable conclusion is that the Lambino Group failed to show to the 6.3 million signatories the full text of the proposed changes. If ever, not more than 1 million signatories saw the petition before they signed the signature sheets. In any event, the Lambino Group's signature sheets do not contain the full text of the proposed changes, either on the face of the signature sheets or as attachment, with an indication in the signature sheet of such attachment. Attorney Lambino admitted this during the oral arguments, and this admission binds the Lambino Group. This fact is also obvious from a mere reading of the signature sheet. This omission is fatal. The failure to so include the text of the proposed changes in the signature sheets renders the initiative void for non-compliance with the constitutional requirement that the amendment must be directly proposed by the people. Through initiative, upon a petition, the signature sheet is not the petition envisioned in the initiative clause of the Constitution. For sure, the great majority of the 6.3 million people who signed the signature sheets did not see the full text of the proposed changes before signing. They could not have known the nature and effect of the proposed changes, which are: first, the term limits on members of the legislature will be lifted and thus members of parliament can be re-elected indefinitely. Second, the interim parliament can continue to function indefinitely until its members, who are almost all the present members of Congress, decide to call for new parliamentary elections. Thus, the members of the interim parliament will determine the expiration of their own term of office. And, lastly, within 45 days from the ratification of the proposed changes, the interim parliament shall convene to propose further amendments or revisions to the Constitution. These three specific amendments are not stated or even indicated in the Lambino Group's signature sheets. The people who signed the signature sheets had no idea that they were proposing these amendments. These three proposed changes are highly controversial. The people could not have inferred or divined these proposed changes merely from a reading or rereading of the contents of the signature sheets. An initiative that gathers signatures from the people without first showing to the people the full text of the proposed amendments is most likely a deception, and can operate as a gigantic fraud on the people. That is why the Constitution requires that an initiative must be directly proposed by the people in a petition, meaning that the people must sign on a petition that contains the full text of the proposed amendments. On so vital an issue as amending the nation's fundamental law, the writing of the text of the proposed amendments cannot be hidden from the people under a general or special power of attorney to unnamed, faceless, and unelected individuals. The Constitution entrusts to the people the power to directly propose amendments to the Constitution. The Supreme Court trusts the wisdom of the people even if its members do not personally know the people who signed the petition. However, this trust emanates from a fundamental assumption: the full text of the proposed amendment is first shown to the people before they sign the petition, not after they have signed the petition. In short, the Lambino Group's initiative is void and unconstitutional because it dismally fails to comply with the requirement of Section 2, Article 17 of the Constitution, that the initiative must be directly proposed by the people, through initiative, upon a petition. As regards the second issue, the Supreme Court resolved that, no, the Lambino Group's proposed amendments to the Constitution, changing the present bicameral-presidential system to a unicameral-parliamentary form of government, are not allowed under Section 2, Article 17 of the Constitution. A people's initiative to change the Constitution applies only to an amendment of the Constitution and not to its revision. In contrast, Congress or a constitutional convention can propose both amendments and revisions to the Constitution. Article 17 of the Constitution speaks of three modes of amending the Constitution. The first mode is through Congress upon 3/4 vote of all its members. The second mode is through a constitutional convention. The third mode is through a people's initiative. Section 1 of Article 17, referring to the first and second modes, applies to any amendment to, or revision of, the Constitution. In contrast, Section 2 of Article 17, referring to the third mode, applies only to amendments to the Constitution. This distinction was intentional, as shown by the deliberations of the Constitutional Commission. There can be no mistake about it. The framers of the Constitution intended, and wrote, a clear distinction between amendment and revision of the Constitution. The framers intended, and wrote, that only Congress or a constitutional convention may propose revisions to the Constitution. The framers intended, and wrote, that a people's initiative may propose only amendments to the Constitution. Where the intent and language of the Constitution clearly withhold from the people the power to propose revisions to the Constitution, the people cannot propose revisions even as they are empowered to propose amendments. In this jurisdiction, there can be no dispute that a people's initiative can only propose amendments to the Constitution, since the Constitution itself limits initiatives to amendments. There can be no deviation from the constitutionally prescribed modes of revising the Constitution. A popular clamor, even one backed by 6.3 million signatures, cannot justify a deviation from the specific modes prescribed in the Constitution itself. As the Supreme Court of Oklahoma ruled in a case, it is a fundamental principle that a constitution can only be revised or amended in the manner prescribed by the instrument itself, and that any attempt to revise a constitution in a manner other than the one provided in the instrument is almost invariably treated as extra-constitutional and revolutionary. While it is universally conceded that the people are sovereign and that they have power to adopt a constitution and to change their own work at will, they must, in doing so, act in an orderly manner and according to the settled principles of constitutional law. And where the people, in adopting a constitution, have prescribed the method by which the people may alter or amend it, an attempt to change the fundamental law in violation of the self-imposed restrictions is unconstitutional. The Supreme Court, whose members are sworn to defend and protect the Constitution, cannot shirk from its solemn oath and duty to ensure compliance with the clear command of the Constitution that a people's initiative may only amend, never revise, the Constitution. The question now is, does the Lambino Group's initiative constitute an amendment or revision of the Constitution? If the Lambino Group's initiative constitutes a revision, then their petition should be dismissed for being outside the scope of Section 2, Article 17 of the Constitution. Courts have long recognized the distinction between an amendment and a revision of a constitution. Revision broadly implies a change that alters a basic principle in the Constitution, like altering the principle of separation of powers or the system of checks and balances. There is also revision if the change alters the substantial entirety of the Constitution, as when the change affects substantial provisions of the Constitution. On the other hand, the amendment broadly refers to a change that adds, reduces, or deletes without altering the basic principle involved. Revision generally affects several provisions of the Constitution, while amendment generally affects only the specific provision being amended. In California, where the initiative clause allows amendments, but not revisions to the Constitution, just like in our Constitution, courts have developed a two-part test: the quantitative test and the qualitative test. The quantitative test asks whether the proposed change is so extensive in its provisions as to change directly the substantial entirety of the Constitution by the deletion or alteration of numerous existing provisions. The court examines only the number of provisions affected and does not consider the degree of the change. The qualitative test inquires into the qualitative effects of the proposed change in the Constitution. The main inquiry is whether the change will accomplish such far-reaching changes in the nature of our basic governmental plan as to amount to a revision. Whether there is an alteration in the structure of government is a proper subject of inquiry. Thus, a change in the nature of the basic governmental plan includes change in its fundamental framework or the fundamental powers of its branches. A change in the nature of the basic governmental plan also includes changes that jeopardize the traditional form of government and the system of check and balances. Under both the quantitative and qualitative tests, the Lambino Group's initiative is a revision, and not merely an amendment. Quantitatively, the Lambino Group's proposed changes overhaul two articles, Article 6, on the legislature, and Article 7, on the executive, affecting a total of 105 provisions in the entire Constitution. Qualitatively, the proposed changes alter substantially the basic plan of government, from presidential to parliamentary, and from a bicameral to a unicameral legislature. A change in the structure of government is a revision of the Constitution, as when the three great co-equal branches of government in the present Constitution are reduced into two. This alters the separation of powers in the Constitution. A shift from the present bicameral-presidential system to a unicameral-parliamentary system is a revision of the Constitution. Merging the legislative and executive branches is a radical change in the structure of government. The abolition alone of the office of the President, as the locus of executive power, alters the separation of powers and thus constitutes a revision of the Constitution. Likewise, the abolition alone of one chamber of Congress alters the system of checks and balances within the legislature and constitutes a revision of the Constitution. By any legal test and under any jurisdiction, a shift from a bicameral presidential to a unicameral parliamentary system, involving the abolition of the office of the President and the abolition of one chamber of Congress, is beyond doubt a revision, not a mere amendment. On the face alone of the Lambino Group's proposed changes, it is readily apparent that the changes will radically alter the framework of government, as set forth in the Constitution. We can visualize amendments and revisions as a spectrum, at one end, green for amendments, and at the other end, red for revisions. Towards the middle of the spectrum, colors fuse and difficulties arise in determining whether there is an amendment or revision. The Lambino Group's initiative is indisputably located at the far end of the red spectrum, where revision begins. The Lambino Group's initiative seeks a radical overhaul of the existing separation of powers among the three co-equal departments of government, requiring far-reaching amendments in several sections and articles of the Constitution. Where the proposed change applies only to a specific provision of the Constitution, without affecting any other section or article, the change may generally be considered an amendment, and not a revision. For example, a change reducing the voting age from 18 years to 15 years is an amendment, and not a revision. Similarly, a change reducing Filipino ownership of mass media companies from 100% to 60% is an amendment, and not a revision. Also, a change requiring a college degree as an additional qualification for election to the presidency is an amendment, and not a revision. The changes in these examples do not entail any modification of sections or articles of the Constitution, other than the specific provision being amended. These changes do not also affect the structure of government or the system of checks and balances among or within the three branches. These three examples are located at the far green end of the spectrum, opposite the far red end, where the revision sought by the Lambino Group's petition is located. However, there can be no fixed rule on whether a change is an amendment or a revision. A change in a single word of one sentence of the Constitution may be a revision, and not an amendment. For example, the substitution of the word Republican with monarchic or theocratic in Section 1, Article 2 of the Constitution, radically overhauls the entire structure of government and the fundamental ideological basis of the Constitution. Thus, each specific change will have to be examined case by case, depending on how it affects other provisions, as well as how it affects the structure of government, the carefully crafted system of checks and balances, and the underlying ideological basis of the existing Constitution. Since a revision of a constitution affects basic principles, or several provisions of a constitution, a deliberative body with recorded proceedings is best suited to undertake a revision. A revision requires harmonizing, not only several provisions, but also the altered principles with those that remain unaltered. Thus, constitutions normally authorize deliberative bodies, like constituent assemblies or constitutional conventions, to undertake revisions. On the other hand, constitutions allow people's initiatives, which do not have fixed and identifiable deliberative bodies or recorded proceedings, to undertake only amendments, and not revisions. Now, what unicameral parliamentary form of government do the Lambino Group's proposed changes refer to? The Bangladeshi, Singaporean, Israeli, or New Zealand models, which are among the few countries with unicameral parliaments. The proposed changes could not possibly refer to the traditional and well-known parliamentary forms of government, the British, French, Spanish, German, Italian, Canadian, Australian, or Malaysian models, which have all bicameral parliaments. Did the people who signed the signature sheets realize that they were adopting the Bangladeshi, Singaporean, Israeli, or New Zealand parliamentary form of government? This drives home the point that the People's Initiative is not meant for revisions of the Constitution, but only for amendments. A shift from the present bicameral-presidential to a unicameral parliamentary system requires harmonizing several provisions in many articles of the Constitution. Revision of the Constitution through a People's Initiative will only result in gross absurdities in the Constitution. In sum, there is no doubt whatsoever that the Lambino Group's initiative is a revision, and not an amendment. Thus, the Lambino Group's initiative is void and unconstitutional, because it violates Section 2, Article 17 of the Constitution, limiting the scope of a people's initiative to amendments to the Constitution. As to the last issue, the Supreme Court resolved that, no, a revisit of the Santiago case is not necessary. The Lambino Group's petition warrants dismissal for failure to comply with the basic requirements of Section 2, Article 17 of the Constitution, on the conduct and scope of a people's initiative to amend the Constitution. There is no need to revisit the Supreme Court's ruling in the Santiago case, declaring Republic Act No. 6735 incomplete, inadequate or wanting in essential terms and conditions to cover the system of initiative to amend the Constitution. An affirmation or reversal of the Santiago case will not change the outcome of the Lambino Group's petition. Thus, the Supreme Court must decline to revisit the Santiago case, which effectively ruled that Republic Act No. 6735 does not comply with the requirements of the Constitution to implement the initiative clause on amendments to the Constitution. The Supreme Court must avoid revisiting a ruling involving the constitutionality of a statute, if the case before it can be resolved on some other grounds. Such avoidance is a logical consequence of the well-settled doctrine that courts will not pass upon the constitutionality of a statute, if the case can be resolved on some other grounds. Nevertheless, even assuming that Republic Act No. 6735 is valid to implement the constitutional provision on initiatives to amend the Constitution, this will not change the result here, because the Lambino Group's petition violates Section 2, Article 17 of the Constitution. To be a valid initiative, the Lambino Group's initiative must first comply with Section 2, Article 17 of the Constitution, even before complying with Republic Act No. 6735. As a final remark, the Supreme Court emphasized that the Constitution, as the fundamental law of the land, deserves the utmost respect and obedience of all the citizens of this nation. No one can trivialize the Constitution by cavalierly amending or revising it in blatant violation of the clearly specified modes of amendment and revision laid down in the Constitution itself. To allow such change in the fundamental law is to set adrift the Constitution in uncharted waters, to be tossed and turned by every dominant political group of the day. If the Supreme Court allows today a cavalier change in the Constitution outside the constitutionally prescribed modes, tomorrow, the new dominant political group that comes will demand its own set of changes in the same cavalier and unconstitutional fashion. A revolving door constitution does not augur well for the rule of law in this country. An overwhelming majority, 16,622,111 voters, comprising 76.3% of the total votes cast, approved our Constitution in a national plebiscite held on February 11, 1987. That approval is the unmistakable voice of the people, the full expression of the people's sovereign will. That approval included the prescribed modes for amending or revising the Constitution. No amount of signatures, not even the 6,327,952 signatures gathered by the Lambino Group, can change our Constitution contrary to the specific modes that the people, in their sovereign capacity, prescribed when they ratified the Constitution. The alternative is an extra-constitutional change, which means subverting the people's sovereign will and discarding the Constitution. This is one act the Supreme Court cannot and should never do. As the ultimate guardian of the Constitution, the Supreme Court is sworn to perform its solemn duty to defend and protect the Constitution, which embodies the real sovereign will of the people. Incantations of people's voice, people's sovereign will, or let the people decide, cannot override the specific modes of changing the Constitution, as prescribed in the Constitution itself. Otherwise, the Constitution, the people's fundamental covenant that provides enduring stability to our society, becomes easily susceptible to manipulative changes by political groups, gathering signatures through false promises. Then, the Constitution ceases to be the bedrock of the nation's stability. The Lambino Group claims that their initiative is the people's voice. However, the Lambino Group unabashedly states that it maintains its unqualified support to the agenda of Her Excellency, President Gloria Macapagal-Arroyo, for constitutional reforms. The Lambino Group, thus, admits that their people's initiative is an unqualified support to the agenda of the incumbent president to change the Constitution. This forewarns the Supreme Court to be wary of incantations of people's voice or sovereign will in the Lambino Group's initiative. The Supreme Court cannot betray its primordial duty to defend and protect the Constitution. The Constitution, which embodies the people's sovereign will, is the Bible of the Supreme Court, which exists to defend and protect the Constitution. To allow this constitutionally infirm initiative, propelled by deceptively gathered signatures, to alter basic principles in the Constitution, is to allow a desecration of the Constitution. To allow such alteration and desecration is to lose the Supreme Court's reason for its existence.